Welcome back to Law and Crime, everyone, and welcome again to those of you listening on Sirius XM Satellite Radio. I'm Aaron Keller. I'll be with you for the next few hours today. We're talking about the Yesenia Sesmas case out of Wichita, Kansas, the case of a woman who's accused of killing the mother of a child, taking the child across state lines, and passing that child off as her own. Those are the core accusations. There's first-degree murder, there's kidnapping, there's interference with parental custody. Those are the three charges. But they're really, really serious charges, of course. Rachel Kugel is an attorney. She's joining us here on the Law and Crime Network to break some of this down. And Rachel, the headline of the hour is that the trial is on pause because the defendant is complaining of chest pains. And of course, what has to happen then is everything has to shut down and the defendant has to go get checked out at the hospital. Yeah, I mean, so first of all, we have to make sure that she's okay. Obviously, that's a big part of it. But also, they have to make sure she can participate in her defense. So whether this is an actual physical ailment or some kind of mental, anxiety attack type of situation, either way, they need to check it out before they continue. We certainly want to be clean about this. We don't want to do anything that would set up an appeal just based on, her physical state. Exactly. She has a right to be present at her own trial, and as you said, participate in her defense. There are circumstances, though, where a trial can continue without a defendant, but they're really, really strong circumstances. It has to be a really high bar. It has to be a truly unruly defendant. Yeah, so you could be removed by being unruly, certainly, but that is obviously very rare. I mean, the other thing, and people get, we call it Parker warnings here in New York, but at the beginning of any trial, a judge warns a defendant that if they purposely abscond, if they make themselves unavailable, then it can occur in their absence and go forward with it. Here, arguably, if there's some kind of medical condition, they need to check that out before they make any determination about that. We are hearing that things might come back into a live session in the Yesenia Sesmas case around 2 o'clock Eastern. That's a couple hours from now. So bear with us. We're just rolling with things as they roll in the courtroom here on Law and Crime. We're going to go back to that testimony of Eric Guzman. He's the one who recovered the text messages back and forth between the defendant and the victim. You're listening to real testimony in a real-life murder trial out of Wichita, Kansas. The defendant, Yesenia Sesmas, is accused of first-degree murder, kidnapping, and interference with parental custody. The accusations are that she approached a friend, demanded that the friend give her the baby that the friend had birthed and raised, and that when the friend refused, a gun just happened to go off, shooting the friend in the head. The defendant took off with the child. That's the accusation. We're in the midst of this trial now in Wichita. Rachel Kugel is here on the Law and Crime Network to help us break it down. Rachel, look, these text messages aren't a smoking gun. The key is the subtlety. The key is what they don't say. Yeah, I think so. I mean, we were talking about it while we watched that testimony. I think what it comes down to is it's not about what's in those text messages because they're very subtle and very vague, quite frankly. It's about what's not in them and related to the defense that we expect to hear from this defense team in this case. What we know it is not there is any discussion of getting together for the purpose of watching her baby or taking her baby, any discussion about, I don't want to raise this baby, please raise the baby for me. Nothing like that, which is part of what this defendant suggests happened here. And most of those messages are just about not even coming over to be a friend, bringing soup, caring for your friend. Nothing really about plans for this baby or babysitting or anything like that. The other thing of interest is that there appears to be some text messages that come through after the fact. So unfortunately, when this mother's already been killed and this baby's already been taken, allegedly this defendant continued to text, arguably to cover up her tracks. I think that's where the prosecution It was thinly veiled, but look, I mean, hypothetically, if we had a text that said, hey, I'd like to watch the baby for a few days or for a couple of days, or can you watch my baby for a couple of days? And the answer back is yes to either of those inquiries launched by either side here, we wouldn't even be having this case. We'd be looking for some unknown defendant out there. Yeah, I mean, I think it's what led them to her, certainly, but I also think it goes overall to the weight of this defense in general and how successful it has a chance at being, because the problem with it is, even if it doesn't go directly, it's certainly not a defense that she wanted or intended to take the baby, and that's why she killed this woman. But the problem with it is that it doesn't support her story overall. And because remember, her theme here is that this was an accident. If it at least corroborated the theme, even if it didn't provide a defense, it might provide some more weight for
for her story and the truth of it. The problem to me is, it doesn't give a lot of weight to the story that the defense is trying to sell to this jury.
Well, we have a little bit of time here on the Law and Crime Network because the defendant complained of some kind of a chest pain or something similar to that. The judge shut the trial down for a little while the defendant could get checked out at the hospital to make sure there either is a medical issue that needs treatment or that there is no medical issue and that the trial can continue. That examination is going on as we speak. As we understand it, trial might, if we're lucky, resume in about an hour 45 from now. We're going to go back to the beginning of the case and put all of this evidence we're discussing into some context with the prosecution's opening statement. That's a bit of the prosecution opening statement in the Yesenia Sesmas case out of Wichita, Kansas. We're going to take a quick break here on the Law and Crime Network. When we come back, we're going to break this down a little bit further for you and give some suggestions as to where we think the testimony is going to go from here once the case resumes. I'm pouring through the police reports as we speak. We're going to break down some of what's in those police reports when we come back. Welcome back to the Law and Crime Network, folks, and thanks again if you're listening to us on Sirius XM Satellite Radio. We're talking about a real-life murder case out of Wichita, Kansas that a jury is hearing right now as we speak. This is the Yesenia Sesmas case. She's accused of shooting a mother right in the head and taking that mother's infant child to Dallas, Texas, where the defendant is accused of trying to pass that child off as her own baby. I've been looking through some of the police reports in this case. Rachel Kugel is here with me. She's going to help me break them down. And in the police reports, Rachel, there's a description of what comes very close to being a confession from the defendant, but not quite. And this is some of the evidence that we expect to come out in this case when things pick back up. We haven't heard a lot of this yet in court, but surely this is going to wind up in front of the jury. The defendant saying that she confronted the victim about giving the baby to her, meaning to the defendant, but the victim refused and said the defendant was crazy. The defendant said she became angry and that she had this firearm with her, this gun that she bought on the street somewhere in Texas. And then it gets a little bit confusing in the police report as to exactly who said this, but someone said, either the victim or the defendant, that the gun wasn't real. Somebody said that. So, again, this is the victim's version of the story, the defendant's version of the story. The defendant said she put her arm around the victim and put the gun to her head. Yeah. And then the next thing that the defendant said happened was that the gun went off and struck the victim in the forehead and she bled. Then she goes into a description about exactly how she took the baby, basically putting the baby in a diaper bag and taking off, leaving town. Yeah. Now, it's a graphic description of what happened here, but does it make sense?
Well, I mean, I think there's an interesting thing going on in this case, which we've all been watching even so far with the initial witnesses, is that there are a lot of witnesses, including the defendant, that don't speak English. Or speak very limited English. And so we're dealing with not only trying to piece together the facts of a case and hopefully piecing that together for a jury, but also the added issue of having translators. So I am wondering, I don't think we have the answer to this yet, whether the confusion in that affidavit in those police reports is a result of, translating something in the exact way it's written, even though it seems now, when translated to English, to not make as much sense, or whether it shows some diminished capacity of some kind on the part of the defendant insofar as she was confused about the story she was telling. It's certainly an attempt. I think what is clear is that it's an attempt at mitigating her circumstances when she's confessing.
Yeah, but look, I mean, what I'm asking is, does it make sense for someone to say that they put a gun to someone's head and then the gun went off and struck the person in the forehead? That sounds more like a deliberate shot, and certainly that's what the prosecution is going to argue.
Yeah, and I think what it shows, and it's something that we see in serious cases and even in not so serious cases, most defendants talk, to the police. That's just the reality of being a lawyer. Most clients talk. And what happens when they talk is that a lot of times they will tell what they think is necessary to be told and yet withhold something or say something that they think mitigates somehow the story. So I think maybe what happened here is she's making essentially a confession, but she's telling it in such a way that she feels, without a legal background at the time, is mitigating her guilt by saying it was an accident. Even though it doesn't really make sense in terms of the facts that she's describing, she's trying to somehow, you know, confess, but at the same time pull herself out of some of the responsibility.
Well, she probably assumed, if she thought it all the way through, that there was going to be some evidence that she was there at the location. She's just trying to explain it away.
Right.
But in trying to do so, if this indeed was her intent, she actually, you know, admits putting the gun to the victim's head. You know, guns tend not to go off on their own. That's just not the way it works. So, look, jurors are going to have to try to make sense of all this. We're in the midst of listening to the prosecution's opening statement in this case. Again, we're talking about the Yesenia Sesmas case, Yesenia Sesmas case out of Wichita, Kansas. And it's a case where a woman is facing murder and kidnapping charges, accused of shooting that victim and taking that victim's child. This is the Yesenia Sesmas murder trial, which is being heard by a jury right now in Wichita, Kansas. Let's break down some of what we just heard there in a look back at the prosecution's opening statement. Rachel Kugel is an attorney. She's here with us on the Law and Crime Network. Rachel, a couple of stylistic things. I like this prosecutor's style. It's firm, it's matter of fact, it's even keeled, and it allows the jury to think. Oftentimes, prosecutors like to get up and be bombastic, thinking that they can just ram it in. Here, I like this style because I can focus on the evidence. I can focus on the facts. I'm absorbing it. I'm not being forced to believe it.
Yeah, it's interesting. I mean, certainly opening statement is not about argument yet. It's about showing the jury, you know, what you think the evidence will show, what you expect. You know, it's kind of foreshadowing for them what they will expect to see. And I think he's doing a good job of that. I think in this case that the photos, those ideas sort of speak for themselves in that they are sort of breathtaking in their wildness, that someone would go to, you know, that type of length. I mean, you couldn't write a movie that was more riveting than what this prosecutor is talking about. The facts of this case are themselves dramatic and riveting, and I think he's doing the right thing by relying on that. And
another thing that we saw here is another instance visually of the language barrier. For those listening on Sirius XM, they don't get to see it, but there's an interpreter in court for the defendant. She's not a U.S. national. Presumably Spanish is her most fluent language. We've got an interpreter trying to repeat English legal proceedings in Spanish. That's, as you said, a hard job. It's a hard job for the interpreter. It's also hard for the attorneys dealing with it because you're trying to sort of talk to your client, have your client hear what's going on. You're trying to do all of those things simultaneously. It can also be hard for a jury, and it's a concern, I think, for any attorney on either side because, first of all, it can be confusing. Secondly, it can make things take longer, you know, and so you're already trying to make sure that the jury's kept awake, you know, through testimony, and sometimes that testimony can be hard to sit through, and to essentially have to hear it twice in English and then in Spanish or vice versa can be difficult. So it's an added concern. The main issue is fairness. I don't know what Yesenia's situation is if she speaks English at all, but what's interesting is even if she does, there's a difference between understanding English at some, you know, basic level, the ability to, you know, function in normal life, and understanding it in legalese. We have to make sure, the courts need to make sure that she fully understands what's going on, not just in a conversational way, like I might be able to speak Spanish at some conversational level, but actually understands the legal implications of everything she's hearing and everything that's happening in that courtroom. That's a tall order linguistically, because just because we can go someplace and order a burger at a drive-thru in a language doesn't mean we understand how the court processes are working. So that's another consideration here. Again, this case is on pause right now as we speak on the Law and Crime Network because the defendant said that she was having some chest pain, and the judge hit the pause button and had her taken to the hospital to get checked out. We might have live testimony back about an hour and a half from now, but of course that's to be seen. We will have to wait and see if that happens. In the meantime, we're continuing to listen to the prosecution's opening statements from a couple of days ago. Let's pick up where we left off. Those are the prosecution's opening statements in the case we're talking about right now, the Yesenia Sesmas first-degree murder, kidnapping, and interference with parental custody case out of Wichita, Kansas. This case is on pause right now because the defendant complained of some kind of a chest pain. The judge had to shut down the proceedings because the defendant needed to get checked out at the hospital, and the defendant has to be there to participate in her own defense. Rachel Kugel is here to break this down. Rachel, look, I've been in these trials before. I've seen this happen. I've seen defendants basically fake it.
Yeah.
Okay, I remember watching one defendant in one case putting on the most amateur theatrical performance I have ever seen. Oh, Judge, my heart's given out, and it reeked of a kindergarten performance at any elementary school in America, and everybody knew that it was an act, but the judge had to shut things down, and the defendant was just smiling and relishing with the fact that he could shut down his own trial.
Yeah.
Didn't play that well in front of the jury, but I guess that was, in this case, I'm remembering the defendant's last chance to try to assert power over a system that was asserting power over him. So what is this? Is this legit? Is this an act? What's going on?
Yeah, I mean, it's hard to know at this point. There certainly is malingering in certain cases, for sure. What's interesting, I think, you know, in general terms, is we got to keep in mind that the purpose of the system, as much as, you know, we focus on victims and stories and all that, the purpose of the system really is to make sure that this defendant gets a fair trial. I mean, that really is the judge's purpose. It isn't, at this stage of the game, really about the victim. You know, it's about making sure the defendant gets a fair trial. That benefits everybody, right? Because the more we can be certain that defendant gets a fair trial, if that trial results in a conviction, that conviction is clean. There aren't appellate issues. You know, so it benefits both sides for that defendant to have a fair trial. The judge's main concern during the course of this is to make sure that not just the appearance of a fair trial, but an actual due process right fair trial. And I think that's what you're seeing. It might be an overabundance of caution, but we're making sure that she's having a fair trial. What's interesting is we don't know whether this is an actual medical issue physically or whether it relates to some mental issue and anxieties, something that
I mean, that manifests physically a lot of times. I mean, if she's extremely nervous, worried about her own fate, then that can manifest physically. But they'll get that checked out at the hospital.
They will, and the reason that they're doing it, as I indicated, is really to make sure it's essentially a due process right. She has a right to be present, but it's also making sure that that's a fair trial. So we can't have someone sitting there, you know, God forbid, on the one chance that someone is really having a physical issue. You know, this is real life. These things happen in real moments, and you know, lawyers keel over and defendants keel over, and we need to make sure.
How often have you actually seen that, though, and had it be legitimate?
Well, yeah, I mean, maybe I'm a little bit jaded at this point, but I'm going to say it's rare that it's legitimate, and it's certainly a concern that it would affect the jury. I wonder how much the jury actually knows about what's going on at this point.
I've seen it twice, and I've not seen it be legitimate ever. So we'll have to wait and see here. As you say, maybe it could be. We're gonna keep an eye on this case. We're going to take a quick break. We'll come back in just a moment with our analysis of the Yesenia Sesmas case out of Wichita, Kansas. You're watching the Law and Crime Network, folks, and thanks again if you're joining us on Sirius XM Satellite Radio. I'm Aaron Keller, and we're continuing to break down the Yesenia Sesmas case out of Wichita, Kansas. If you're just joining us, it's a first-degree murder, kidnapping, and interference with parental custody case involving a woman who's accused of shooting a friend right in the head, taking that friend's baby, and passing that baby off as her own child to friends and relatives. Rachel Kugel is an attorney. She's here breaking this case down with us. Rachel, we just listened before the break to the prosecution's opening statement. It laid out the case very matter-of-factly, helped the jurors absorb a lot of the evidence that was going to come up. But we're going to shift gears now and talk about the defense opening statement. It was kind of a non-opening opening, and we're trying to figure out where the defense might go, because in Kansas, there is no true mental disease or defect or insanity defense, not the way other states recognize it.
Yeah, I mean, I'm riveted by this, and the more we're watching this together and talking about it, I now can't wait to see where they're going to go with it. So our understanding is there is no direct insanity defense in Canada. I mean, in Kansas.
That cameras
I don't know what
Canada,
happens again.
So we're not there.
But that said, there still could be the ability to use the issue to possibly bring down or go to a mental state and bring down a charge. In other words, they've charged her with first-degree murder. That requires certain levels of culpable mental state. They could,
in other words, intent.
Yes.
Some states require premeditation, things like that.
Correct. And so possibly they could use a mental disease or defect. And the statute, I was looking it up on the break, does allow for it not to be used as a direct offense, but to be used to mitigate the culpable mental state required of any specific crime. So that the opening statement was very vague. We don't know where they're going at this point. We don't know if they're going pure accident. We don't know if they're going some type of mental disease or defect that reduces a culpable mental state. We really don't know. And I wonder why they have waited to tell us that. You know, behind the scenes, are they still wrestling with that themselves? You know, are they still trying to put the pieces of that defense together themselves? Believe it or not, sometimes right up until that 11th hour, as defense attorneys, we're working on that strategy and trying to flesh it out. They could be disagreeing with their client on what the appropriate defense should be.
We're going to have to wait and see. Well, with that context, let's listen to the defense opening statement. It was a bit of a non-opening, but let's see if we can look at it through the window that we've just given and see if we can pick up on a clue here. That was the defense opening statement in the Yesenia Sesmas case out of Wichita, Kansas. It's a first-degree murder case, but as you just heard, Rachel, the defense in what we oftentimes call a non-opening opening, in other words, one that doesn't give another theory of the case, basically begged the jurors for some kind of a lesser verdict. Yeah. Interesting tactic, but it certainly wasn't an awe-inspiring presentation here.
By no means. And really what he did, even more sort of boring than that, was he sort of just read them the statutory requirements to be convicted. I think it's an interesting choice. So you have the choice to waive an opening statement, and he didn't want to do that. He wanted to introduce himself and speak to the jurors a little bit. He chose not to waive it. But you also don't want to overpromise. You don't want to tell a jury they're going to hear something and then have them not hear it. That's sort of an attorney's worst nightmare, is to promise something to the jury and then have that not, come out. What I can't figure out is why you'd make the choice to not tell the jury what your theory of the case is at this point. Is it accident? Is it mental disease or defect? What is your theory? He told us that we should convict her of something less. He told us that we should be focused on that mental state, but he didn't tell us why. Is this an accident? He didn't tell us what his client's position or their theory of the case is. Strategically, I can't figure out why he would do that, short of that maybe he's not sure yet, that they're still fleshing out how they're going to piece this together for the jury and what's going to be their best defense, or that they're actually arguing with their own client about what maybe they want to put up a mental issue and she doesn't want to. Who knows what's going on behind the scenes, but I'm willing to bet it's more than what we're seeing in that relatively bland opening statement.
Yeah, I mean, we don't know, and of course that's what we always wish we could know, but we also know why we can't know. And here, I guess at some point you got to come up with a plan because you're already in it, but I would hope that the plan was arrived at long before now.
You would hope it, but the reality of trial law and this kind of practice is that sometimes it isn't fully fleshed out. And that could be because, you and the defendant don't agree. It could be for a variety of reasons. It could be because you're trying to flesh it out and you're not sure that your expert witness is going to do it. It may be because they think she needs to testify and they haven't decided in order to make out one type of defense or another, and they haven't made that determination whether that makes sense. They want to hear. Don't forget, the state gets to go first, right? So they may want to hear the state's case, see how it comes in and how it holds up, and then make some of their decisions on the fly. But also defense attorneys don't have the same concerns of being appealed in the way that the state does. So usually in these cases, we see a much more boring and bland prosecutor because he's worried about being appealed by using flowery or passionate, persuasive language. And we usually see a much more energetic, high-energy defense that's filled with passion. We don't see that here. Doesn't mean it's not coming, but it certainly hasn't come yet.
Yeah, okay, so one other issue that I want to bring up here about this is this. What is it that goes through the mind of attorneys that they can get up there and blandly read the law like this to the jury and assume the jury is going to understand it? If you want to get into a complicated discussion about mental state, you got to find a way to level with that jury and say, hey, look, folks, on the streets, this is what we're really talking about. You're going to hear this buzzword. You're going to hear this buzzword. This is what it really means. These are examples of it. And in this case, the state can't prove the big top mental state, and here's what. You got to break it down in a much more clear manner.
On a much more sort of emotional, energetic level, if you are not passionate as an advocate for your client, then how can you expect the jury to get on your side and be passionate about the theory of your case that you're using to hopefully defend your client? I'm going to give them the benefit of the doubt and hope that this is a choice and not just sort of indifferent defense strategy. And where I can get behind it as a choice is that for some reason they don't know yet. And so he's being careful and cautious, and it's reasoned as opposed to just, to level with you and be blunt, boring.
That could be. Well, we're going to find out as this case rolls along. Again, we're talking about the Yesenia Sesmas case out of Wichita, Kansas, a first-degree murder, kidnapping, and interference with parental custody case. This case is on hold because the defendant complained of chest pains, had to get checked out at the hospital. The judge is saying maybe they're going to come back in session at around 2 o'clock Eastern time. We're waiting to see if that actually is going to happen. In the meantime, the child's father, this is the kidnapped child's father, Manuel Antonio Gonzalez, was on the witness stand. We couldn't see him actually testify, but we could hear him. So we're going to listen to that now. That was testimony from Manuel Antonio Gonzalez, the father of the child, who authorities say was kidnapped by this defendant, Yesenia Sesmas, after Sesmas killed that baby's real mother by shooting her in the head. Interesting case out of Wichita, Kansas. We're going to take a quick break. We'll be back in a moment. Welcome back to the Law and Crime Network, everyone. I'm Aaron Keller. We are going to get you caught up on some of the top crime stories making headlines across the country now. Welcome back to Law and Crime, everybody. I'm Aaron Keller. We're talking about the Yesenia Sesmas case out of Wichita, Kansas, the case of a woman who's facing first-degree murder charges, kidnapping charges, and interference with parental custody charges related to the shooting death of the mother of the child this defendant is accused of taking. Rachel Kugel is here to help us break this case down. I want to talk a little bit about the testimony of this poor man who's on the witness stand. The father of the child, it's going through an interpreter. He came home from work, found the mother of his child dead, found the child missing. Didn't know what happened to her. Yeah,
it's riveting testimony, and it's interesting that Ms. Sesmas did not have heart palpitations or chest pains during any of this emotional testimony, but instead, I believe it was during the very basic cell phone ping testimony. So it appears the emotional stuff didn't get to her. What's interesting, too, is, we were discussing this, I think that probably part of what we're seeing with these attorneys and the way they're acting and the way they're speaking, and it's different than some of the other ways we've seen them talk on other trials in the past, is maybe because of the interpreter. And because the attorney has to ask questions in such a way that the interpreter then has time to interpret, hears everything, understands everything. So I think it just in terms of stylistically, we're seeing kind of a calculated asking of questions in a slow manner, and I think that's for no other great reason than the interpreter being there. It adds, an element to this case.
Yeah, we're waiting to see if this testimony in this case, rather, is going to pick up here because of that medical issue with the defendant. The judge is saying it could pick up about an hour from now. We're waiting to see if that indeed is going to be true or if it's going to take longer for this defendant to get checked out at the hospital. So while we wait, let's continue to listen to this testimony from the kidnapped child's father who was on the witness stand recently. Welcome back, everyone. This is the Law and Crime Network. You're listening to testimony in the Yesenia Sesmas case out of Wichita, Kansas. A first-degree murder trial where a defendant is facing that charge along with kidnapping, along with interference of parental custody. The accusation is that she took a friend's baby after shooting that friend in the head. Of course, the state wants everyone to believe that this was intentional, that she planned it all out, because the defendant had been pregnant, had a miscarriage at 5 months, and then continued to act as if she was pregnant. So the state is saying this not only was intentional, but premeditated. Rachel Kugel is an attorney here in New York. She's here to help us break this all down. Rachel, look, it sounds like the state's got a pretty strong case here, because there's months of time where jurors could find premeditation in this case.
Yeah, they do, and that's why I'm leaning toward myself. I'm thinking that the defense would try and use that mental state, because it's the only way that some of those really bad facts, those really bad pieces of evidence, like those photographs of her baby shower, I mean, those things are creepy, knowing that she had a miscarriage and knowing what ultimately, as we now do, would transpire traumatically and horrifyingly. So the only way those things help the defense or turn, spin it your direction is that if they go for some kind of mental state element, because then the crazier she acted, the more out there and wacko the stuff appears, the better for the defense, So I think, if it were me, I would be really exploring that as an option.
So how does it work, though? Because in Kansas, as we've said, there's no true insanity defense. How does it work? Did they just turn around and say she wasn't in the mental state, she wasn't able to form the intent because all the other thoughts were just getting in the way and she was acting almost impulsively?
Yeah, I think they'd have to argue that she is in such a bad mental state, then or now, or both, that she could not form that intent. There's no doubt that they would need medical testimony. She had a miscarriage. She had personally a traumatic event. I mean, it sounds like, if it's true, it sounds like a relatively late miscarriage at 5 months, pregnant. That could certainly be traumatic. She then acted in a way that boggles the mind of any rational person by not telling her family and friends and the father of the baby, and by continuing to go forward with baby showers. I mean, that is something that it sends chills up any of our spines to even hear about. So I don't think it would be hard necessarily for jurors to accept that doesn't jive with their understanding of rational people. Now, whether they could then bootstrap that into, and she wasn't able to form the intent on the day this happened, is a tougher question, especially in light of the fact that, she arguably bought this gun in advance. So there are problems with it, but it just seems to me that given the strength of the state's case, it would be where they should try and go.
Is it possible they could slice and dice the language that the defendant used to the police during an interview when she was arrested, where she said, and again, I'm looking at the police report here, that she put her arm around the victim, Laura, and then put the gun to the victim's head, and then the gun went off. Yeah. Is the defense going to really zero in on that and say maybe she was freaking out herself, she just wanted the baby, she didn't want the mother dead?
Right, she wanted to threaten the mother into making sure that the mother complied, with giving up the baby, I think is the argument. And I think there's also some discrepancy. It'll be interesting to see where, it goes in the future with the police witnesses as well as any defense witnesses. There's information about holding the gun to her in that way, as you just read from that affidavit. But, I was researching also the initial probable cause hearings and such in this matter, and the same police officer, I believe, the testimony there was that the defendants said they were passing it back and forth, the gun. So I think there's going to be that might be a place where the defense can pop in some doubt as to whether she actually was holding it in the way that's described in this affidavit, or whether she was threatening with her, passing it back and forth, and whether there was some question about whether the gun actually was operable and real, whether it worked.
Yeah, there was back and forth about that between the defendant and the victim right before the victim was shot. Well, look, that was really sad testimony we listened to from the father of the child. He was talking there in the last clip about basically coming home from work and finding the mother of his daughter dead in their apartment that they shared. We're going to move now to another family member, the grandmother of the child that authorities say was taken by this defendant. Came from the gym. That was the grandmother of the child who was taken allegedly by the defendant in this case. Again, we're in the Yesenia Sesmas case out of Wichita, Kansas. It's a murder case because the accusation is that not only did Sesmas take the child, but also that Sesmas killed the child's mother in the process of taking the child. Rachel Kugel is an attorney here in New York. She's breaking this case down with us. And here, Rachel, we saw the difficulty of running these questions through an interpreter, but it seems a few times that the witness was jumping the gun with a few answers. So it's likely that the witness has some familiarity with English, but may not be completely fluent.
Yeah, and as we talked about earlier, there's a difference between, conversationally being able to speak English and understanding, legal questions and legal jargon, which is important. I also think, it's a kind of a quiet trial, if you will, just energetically, and I wonder if that has to do in part, with the interpreters and the fact that they're there, and both sides seem to be sort of, aware of it and affecting their style as a result of it. I saw a few things there just watching that testimony that the defense attorney probably could have objected to, and I wonder how much of that is not happening, well, in part because you don't want to, obviously, this witness is very sympathetic, and you don't want the jury to hate you by going after somebody so sympathetic, certainly. But also, I wonder how much of it is just colored by the fact that there are interpreters on both sides. Because I personally saw, they're asking her about how could you tell she was surprised. I mean, I think that's objectionable, potentially. She was surprised to see me. She expected her to be alone, and then I was there. I mean, to me, that's very speculative. There's really no basis for it. I could tell in her face she was surprised. That's a speculative statement at best, and I wonder if it's a strategic choice not to kind of go for her, or if it's because it's not, maybe that important, he thinks, in the grand scheme of things, and so he's kind of just laying low. But the result for us as watchers, I think, is a decidedly kind of quiet trial.
It is, and some of that's cultural as well. I mean, some of it is the quotient of juries in some parts of the country not being quite as fiery as they are in other states. I mean, New York attorneys tend to be a little bit more boisterous here. Other parts of the country are a little bit more laid back. I know that in some states where I'm licensed, New York attorneys were always used as an example by local bars as who not to be. But those of you who come here are perfectly reasonable people. So, look, but this is a critical point. Attorneys have to know the culture of the jury to which they're arguing. Yeah, you have to play to the jury for sure. And that goes certainly culturally, but it also goes for a case like this. I mean, certainly we're talking about a sad, tragic case. Whether the client meant to do it or didn't mean to do it, there's not much doubt that the defendant is the person who pulled the trigger, and as a result, a baby is motherless, and this happened at only 6 days old. That woman is robbed from her ability of, being with her child and experiencing that new motherhood. So it's a tragic story and a tragic situation, and I suppose that there's also a lot of thought going into making sure that, it's a somber case and a somber kind of outlook and emotion in the room. And I think that's the right choice in a lot of ways. I mean, certainly the decision not to cross, he basically did not cross a lot of these witnesses that have come up so far. I mean, I think it's probably a good strategic choice if we're trying to make sure that the jury doesn't hate us when they're thinking about, legal issues that relate to our client. Exactly. Let's pick up where we left off with testimony from the grandmother there of the child who was allegedly taken by this defendant.
Objection.
Here you have a kidnapped child's grandmother on the witness stand speaking through an interpreter. And Rachel, look, here it's pretty clear cut that there wasn't conversation between the victim and the defendant about what was going to happen with this child. No plan to give the child to the defendant, no plan to have the defendant watch the child, nothing like that. It's the absence of evidence like that that is making the state's case. Yeah, it's a problem, and it's a problem not just for that specific fact, not just for the proof of whether there was some, relationship or plan to adopt or take this baby, but also it's a problem because if we're going to believe the defense's supposed theory of the case, either accident or some sort of mental disease or defect, but either way, we need to buy into their story. And so if their facts don't line up, if there's no corroboration for their story, it's not just a problem for that specific fact to be proven, but it's a problem for the credibility of their theory overall. If it's not matching what this defendant's statement was, the jury's going to have a hard time accepting the rest of the statement. Yeah, I'm seeing the prosecutor here build a very skillful case and covering all the bases very methodically. Yeah. This logic is lining up very, very well for the states. Yeah, and what he's doing too, almost like a chess game or something, is it's almost like very quietly and strategically putting up blocks.
You know, so rather than aggressively coming out of the gate with, yeah, this is what this defendant did and this is what we're going to prove, and passionate about it, what he's doing is putting up blocks. So by putting her into a corner wherein there is no evidence of the side of the story she's telling, she's backing them into a corner where when we finally get to the police witnesses and the alleged statement that this defendant made, they're now blocked into a corner where none of that can be true. And once one piece of it can't be true, what happens to the rest of it, right? So he's backing them into a place, he's putting up these blocks so that there's really none of this story that can be accepted by the jury.
Yeah, let's continue listening to the testimony of the grandmother of the child who was allegedly taken by defendant Yesenia Sesmas after that defendant is accused of shooting that girl's mother, this witness's daughter, right in the head. This is the testimony of the mother of a victim who was found shot in the head and the grandmother of a baby who is allegedly taken by the shooter. The testimony is a bit difficult to listen to because there's an interpreter involved, but look, Rachel Kugel, attorney here in New York City, helping us break this down. The old rule is that 90% of communication is nonverbal. And here I think that that rule applies because even though the actual verbiage is going through an interpreter back and forth between the witness and an attorney, you can tell from the face and the body language of this witness that she was incredibly saddened by what happened. But I also sense some resolution here that she is committed to telling the truth. She is matter of fact, but she is sad.
Yeah, she's very credible. She's very strong and steely, I guess, would maybe be a word that I would use. I mean, I think it's clear that this is obviously extraordinarily emotional for her. I mean, none of us could ever imagine being in her circumstance. But she also has, you know, not just her daughter to get justice for, but her granddaughter to get justice for. And I'm sure that that's playing a lot into her ability to sit there. You know, I think it was a smart choice on the part of the prosecutor to put her up first. You know, start emotional, but also get it out of the way for her. You know, remember, witnesses can't listen. So witnesses are generally sequestered. They can't be in the courtroom if they're going to testify. And so once her testimony is done, presumably then she could be in the courtroom going forward and hear the rest of the trial and be there to support her family.
She could. At that point, she can as soon as she is released. So, look, we're going to take a quick break. We'll be back more with the Yesenia Sesmas case out of Wichita, Kansas when we return. And here the emotion in that grandmother's testimony is coming through in the body language. She's crying on the stand, but she's looking right at the attorney who's asking the questions, not at the interpreter, but at the questioner, and making it very, very clear, look, this is the answer. There is no way my daughter would give away her child, and this is why. And she said it with such a resolute sadness on her face that, look, I believe what she's saying, and I think the jury believed it too. Rachel Kugel is here to break the case down with us. I think you agree.
Yeah, I mean, you know, it's impossible to watch that and not have your heart break for this woman and what her family's had to go through. And you don't have to understand Spanish to know how hard this has been for her, and to really feel, I think she's doing a great job of communicating to the jury, to really feel how that new mother felt about her new baby.
She's answering the questions clearly and with almost too much detail. A few times the interpreter kind of put his hand up to say, slow down a little bit so that I can get this all across, because there were a lot more words coming from the witness than came through the interpreter, and I think that he was trying to catch up and also summarize, of course, ethically, because he has to take his own oath, but he's trying to sum this up and say, my daughter would never give away her child. She had purchased life insurance on the child. She was feeding the child, taking care of the child. And look, I think that life insurance policy is another piece of information that's critical here.
Yeah, I do think, I mean, it sounded like, educated guess here, but it sounded like there was an objection with regard to that. And so what happened, I think you're right, is that she really got emotionally involved in the question and started to answer it in more of the regular way that you and I would speak, and not focused on answering a lawyer's question, but really just letting that emotion flow. And as a result, some pieces of information maybe came in that maybe not have otherwise been admissible.
Yeah, you know, is it hearsay? Is it something like that? But look, I mean, there could be business records of that. We could find out more about that life insurance later on in this case. We'll have to wait and see. But look, let's continue on with some of this horribly emotional testimony from a woman who lost her daughter to a gunshot to the head and then realized that her granddaughter was missing. Thank you. That was testimony from the mother of the victim in this case. Prosecutors say that victim was murdered by this defendant. The defendant wanted the victim's baby and kidnapped the baby. That's the accusation. Rachel Kugel is here with me. And look, we heard a lot more testimony there about this black pickup truck, trying to get some more information about whose it was and why it was in the area, how often it was in the area. And the accusation is, look, that's the defendant's truck.
Yeah. And again, showing that they're going for this witness very calmly and carefully and not really going at her, and which I think is the right choice. But I mean, at first, the question was asked whether there was any information about the car the defendant was driving, and her first answer was no. And then he had to go in and almost lead her, and there was no objection, I don't think, from the other side in that regard. So there's clearly a strategic choice to kind of go easy on this witness, because I think that there might have been some place where he could have jumped up about that. You know, he didn't cross her, he went easy on her. Yeah,
I mean, look, one of the other parts of this, though, is that it seemed to me, what I took away from that is that this witness had seen the vehicle but wasn't quite sure exactly whose it was. Yeah. That she saw it, she inquired about it, she had a conversation. No, that's a nice truck.
Right.
Whose truck is that? Didn't really get that far into it, but she had seen it and it registered and there was some conversation about it.
Right, and now it's out there. And again, to our point that we were talking about earlier, you know, the defense attorney chose not to cross her, and I think that's a wise choice under the circumstances. But what it does do is it lets the prosecutor put up those blocks, because now those things are out there and they're uncontroverted. Right? I mean, he didn't go for her, he didn't cross her. So some of those things, the conversation that occurred in that apartment, the truck, these are all, you know, there was certainly emotional testimony, no doubt, but there's also little tidbits of facts in there about baby showers, about planning, about wanting to keep the baby. All of those facts that got in are now in, and they're uncontroverted.
Look, oftentimes questioning is about collecting these little gold nuggets. Mm-hmm. That's the analogy that my trial advocacy professor used to tell me. You collect the nuggets and then you argue the case. You put them all together for a pot of gold on closing argument, and here that's exactly what the prosecution did. So again, a logical case, a case that is being built one nugget at a time here in the Yesenia Sesmas case out of Wichita, Kansas. We're going to take a quick break here on Law and Crime. We'll be back in just a second. Welcome back to Law and Crime, everyone. We are talking about the Yesenia Sesmas case out of Wichita, Kansas, where a defendant is on trial for allegedly shooting a mother in the head, then taking that mother's child and passing the child off as her own. Bottom line, Rachel Kugel, guest here at Law and Crime, attorney here in New York. This is a really strong case for the state.
It's a really strong case, and I think what we'll all be watching for, I know I will, is to really see where this defense is going to go, because that's the big X factor, the big unknown right now. You know, what is their defense going to be? And we all wait with bated breath for that to resume. So
and I'm waiting for more information about these statements that the defendant herself made, because we have them in the police reports. We know what was said, but I'm waiting for the interrogation recordings and some of that evidence, because the body language in that recording is probably going to be very telling.
Yeah, absolutely. I mean, whether the defendant intends to testify or not, we're going to hear from her in one way or another, because there were statements made in this case. And again, you know, just seeing where this defense is going to go is what I'm waiting for.
Exactly. Well, we're waiting for a lot of things here, but we know that you need to hit the road and work on the cases that you're trying. So Rachel Kugel, attorney here in New York City, appreciate your
insight. Thanks for having me.
Okay. Well, as I mentioned before, there has been a pause in the Yesenia Sesmas case because the defendant herself complained of some chest pains and had to be checked out at the hospital. Of course, this happens sometimes, and oftentimes the accusation is that the defendant is making it up in order to delay the proceedings. And there's some question as to whether or not that's happening here, because there are witnesses in town from Dallas, Texas, where she was arrested. They had to fly up to Wichita. It's a Friday. Look. Does this mean that these witnesses are going to have to stay in the hotel in Wichita just hanging around to testify again on Monday? Does it mean that this case is going to get pushed back late today? We don't know yet. We know that the judge said that they were going to try to come back into session at about 2 o'clock Eastern time. We have heard nothing yet. So we are in a holding pattern with everyone else who is in town in Wichita from out of town as this situation gets straightened out. So while we wait for things to potentially pick up again in the Yesenia Sesmas case, we're going to dial back to the Holly Bobo case that we covered in its entirety here on the Law and Crime Network. We prepared a documentary, Who Killed Holly Bobo? Let's listen to that.